All right, we're going to go ahead and get started. Again, thanks so much for being here. My name is Brian Silva. I'm the Vice President of Outreach and Engagement at Americans United for Separation of Church and State. And tonight's town hall is organized by AU. For 75 years, Americans United has been a nonpartisan, not-for-profit educational and advocacy organization that brings together people of all religions and none to protect the right of everyone to believe as they want and stop anyone from using their beliefs to harm others. We fight in the courts, legislatures, and the public square for freedom without favor and equality without exception. I also want to take a quick moment to invite each of you to our national virtual conference in March of 2022, the Summit for Religious Freedom, or SURF. SURF will feature keynote speakers, panel discussions, workshops, and small group events in support of the work being done for religious freedom, as well as the multiple issues that depend on a strong separation of church and state. You can get more info and pre-register at www.thesrf.org. That's thesrf.org. And I also want to give a thank you and big shout out to our co-sponsors tonight, the Baptist Joint Committee for Religious Freedom, Religious Liberty, or BJC, and the American Federation for Teachers. A couple of housekeeping things before I hand it over to our moderator tonight. Again, we're all happy to have you all in attendance. Please note that if you're a member of the media, you are welcome to stay, but this town hall is off the record. Everyone's audio is muted and the video is off. So please use the Q&A function in Zoom at any time to ask any questions. We will try to get to all of them during or at the end of the panel discussion. Unfortunately, we can't necessarily track all the questions in the chat, though we will try. So we do ask that you please use the Q&A function. This session is being recorded and a link will be sent to all of the RSVPs tomorrow. And now it's my pleasure to introduce and hand it over to our moderator, Rachel Lazar. She's the president and CEO at Americans United, a lawyer, advocate, and strategist who's dedicated her career to making our country more inclusive, working to unite both faith and secular leaders and advocacy organizations on issues including women's reproductive freedom, LGBTQ equality, immigration reform, gun violence prevention, paid leave, and of course now, religious freedom. The Washington Post also published her op-ed on the Carson case we're going to discuss tonight, and I'll put that link in the chat. Rachel, hand it over to you.
Thanks, Brian, and welcome everyone. It's great to be with you all. I am mindful that we're here tonight to talk about a challenging religious freedom case being decided by a Supreme Court majority that is hostile to church-state separation and the rights of so many of us, and doing so amidst a global pandemic that still isn't over nearly 2 years later. And it's easy to feel despair. I hope we can describe the obstacles this evening and simultaneously hold on to the truth that Dr. King described, that the arc of the moral universe, and I'll add certainly of this country, is long, but it bends towards justice. We may well have to play the long game here, but we can do that, and it's worth it because our democracy is at risk. Let me quickly set the table by telling you a little bit about the Carson V Macon case, and then we'll have the panelists discuss the case and argument yesterday and open it up to your questions. Maine is a largely rural state where over 50% of public school districts don't operate their own high schools. There are two ways these school districts can fulfill their responsibility to provide an education for their students. One is by contracting with a nearby public or private school, and the other is by funding tuition at an approved non-religious private or public school that the parent chooses. Fewer than 5,000 Maine students reside in school districts that provide these tuition payments. In Carson V Macon, two sets of parents in this last category claim that the Constitution's promise of religious freedom actually requires the state to fund their kids' religious education as a substitute for public education. Both schools where the parents in the case want their kids' tuition funded are fundamentalist Christian and seek to instill a, quote, biblical worldview in students. And it's just one type of biblical worldview too. Bangor Christian teaches students to, quote, refute the teachings of the Islamic religions with the truth of God's word, and views the husband as, quote, the leader of the home. Neither school will hire members of the LGBTQ community or non-Christians as teachers or admit them as students. Temple Academy, for example, forces teachers to sign employment agreements stating that, quote, homosexuals and other deviants are perverted, and even rejects any student with same-sex parents. So we can already see how this case is about state-funded discrimination as much as it's about the traditional concept of religious freedom. And this case comes during a time when the Supreme Court has been redefining religious freedom in very troubling ways. And just to name a few of the many cases, in 2002, the court upheld private school vouchers, even though under most voucher programs, the lion's share of the government money ends up in religious schools. In 2017, the court ruled that a Missouri church's preschool could not be excluded from a local government playground improvement program. And last year, in the Espinoza case, the court ruled that if a state establishes a school voucher plan that's tax credit funded, it must allow religious schools to take part. So fast forward to this Carson V Macon case, and it's about whether a state can be required to fund specifically religious education as a substitute for public education. It was originally filed in 2018, and both the US District Court and the First Circuit ruled in favor of the state of Maine. And now the Supreme Court agreed to hear the case. So before we talk about yesterday's oral argument, let me introduce and bring on our panelists. So hopefully they're coming into the picture. I'm not really sure I can tell, but hopefully thumbs up from everyone. So first I'll introduce, all right, thumbs up, thank you. Richard Katzke, who's my colleague. He's the Vice President and Legal Director at Americans United, and he is a nationally recognized First Amendment expert and advocate. Richard is sort of a legend in the religious freedom world, and very much proud to have him on staff. When I arrived at AU, I begged him to stay forever. And he actually may well have his first Supreme Court argument this term, which would be a tall order that no one is better equipped for than Richard, but overall it's not good news if it happens for church-state separation. Holly Holman is a friend, and also general counsel and the associate executive director at BJC, formerly known as the Baptist Joint Committee for Religious Liberty. Holly provides brilliant legal analysis and advocacy for church-state issues that arise before Congress, the courts, and administrative agencies. She's a critical and longstanding partner for AU in this work, and BJC is such an important faith-based voice for church-state separation. And Randy Weingarten is the president of the 1.7 million member American Federation of Teachers. Randy is a formidable advocate for public schools and for inclusion in this country, and an incredible ally to Americans United. So thanks so much to the three of you for being here with us tonight. So I'm gonna kick it off by asking our panelists some questions, and then we'll be opening it up to your questions. There's a Q&A at the bottom that you can please feel free to add your questions to as we go. So let me get going. I guess I'd like to start by just asking for your thoughts on what's at stake with this case. So Randy, I see you nodding. Do you want to go first?
And I'm so glad, Rachel, that I could be on this panel, and I'm with you. You are, as Richard's, I mean, you talked about how brilliant the other two folks are. You have been just indefatigable, and it is really wonderful to have you in this position at this moment, because there is a hostility on this court to anything that is not within what, justices, at least 4 of the justices believe is their, maybe 5 of the justices believe is their personal worldview. And I don't know if we've ever seen that. I certainly haven't seen that in my lifetime. And you could see that in the argument here. You could see that in the argument over the abortion case. I'm, and once Espinoza went the way Espinoza went, it felt like every other case that dealt with the twin concepts of free exercise, but no establishment of religion within the First Amendment, that free exercise was essentially going to be ruled as or interpreted as, whatever the religious organization that is bringing the case wants, they get. And so it's been very, for those of us who kind of grew up with the no establishment of religion piece of that clause being all controlling, this essentially 180-degree change is legally, but I only play a lawyer these days. I don't actually practice law anymore. Legally, it's challenging and chilling, but effectively for schools, or it is really, really chilling. And the Maine case is a perfect example, because at the end of the day, many, many, many states essentially have a public school system which they fund by public school dollars, and they require no discrimination and all sorts of other kind of dignity rules and regulations, as well as educational rules and regulations to ensure that we are treating all kids who go to public schools fairly, without discrimination, and giving them the resources and the support they need to thrive, both emotionally, socially, and academically. And in this moment in time, it's more important than probably ever before. I've been in about 64 schools since August 1st, and the level of need this year, without exception, when I ask teachers the question of how is this year, people will say to me, this is the hardest year I've ever had teaching. So every dollar is needed, and needed in terms of kids' recovery because of the isolation from COVID, recovery from the polarization of the country, recovery because we're in the middle of a racial reckoning, as well as all of the academic pieces. And whether you agree with them or not, all of the pieces of the pie about making sure that academically we are helping all kids succeed. We are having, test scores or all sorts of other academic requirements to see if kids are succeeding, as well as the non-discrimination and the equity and equality requirements that really were part of the Johnson, not only war on poverty, but the start of the educational department's civil rights mission, which was why the federal government got into education in the first place, dating back to Brown versus Board of Education. I say all of that because it's a setup to essentially just say everything's at risk. The Brown versus Board of Education and the compulsion that separate is not equal, the absolute requirement of non-discrimination, particularly to marginal groups, whether they're Indigenous kids or trans kids or Black and brown kids, and then the whole issue about siphoning off public funds for public education, particularly when we don't have enough investment. All of that is at risk with this case. And so the question is, and this is where I'll end, that how is it that a new interpretation of free exercise can actually viscerate or eviscerate every single other constitutional provision that our public school system has been built on. And that's really the question. And I say it again, as a lawyer that's not really practicing, but as an educational person, that's really the question in this case. How could all of a sudden the free exercise clause eviscerate everything else, particularly when the free exercise clause is mirrored by no establishment of religion? So everything is at stake in this case if they decide that the moment you have $1 for public schools, you got to have that same dollar for everything else, particularly religious schools. And that's the big question mark. Even though the decision, even though the argument went in a certain way that maybe that doesn't happen, that's really what the advocates for privatization really want.
I want to open it up to Holly and Richard to come in on that. You both being practicing lawyers in this space, I imagine you have a lot to pick up on.
Well, the way I would put it is that what's at stake is really whether and under what conditions public funds, tax-supported funds for government entities, and particularly public school funds, can be reserved for public purposes. And not diverted to explicitly religious activity. And I think as Randy was talking about this 180, yes, under the Constitution's dual protections of free exercise and no establishment, it had long been the case that, we expected that the government would not be involved in explicitly religious activity. And in thinking about the 2 decades since the Zellman case, I know most people are familiar with that as the first time the court found it was permissible to allow funding to go to religious education. They only did that by coming to a conclusion that the state or the city there had come up with this true private choice way that the benefit really was broadly available and religiously neutral. And while that was a loss for all of us who are so dedicated to public schools, it never, in no part of that decision, did it ever hint at the idea that the Constitution could require states to spend money on religious education. So that's that 180 that we're experiencing, even by the question being presented. So there's this real significant shift going on in the court, and what's at stake is really, I think, not only public schools, and we'll talk more about the damage that can be done there, but religious freedom and understanding how it protects the distinctive role of religion in people's lives, to understand that religion is practiced through prayer and worship and persuasion and all these ways, and that it is a distinct activity that states, for very good reason, should be able to stay out of sponsoring. So that's what I'm really afraid is at stake and maybe that we may be losing.
So the good or bad thing about being with smart panelists is I can say, yeah, what they said. The things that I'm thinking a lot about are the changes that we've seen today. I guess I want to say 2 different things. One of them is that what I see many on the Supreme Court doing is accepting a redefinition of what it means to not discriminate on the basis of religion. That's sort of what used to be considered religious neutrality. Government stays out of religion, which is supposed to protect religion as well as government in the ways that Holly was saying. That the concept of neutrality meant the government was supposed to be hands off, right? And one of the things that did, getting back to what Randy was talking about in the public school context, is the public schools were supposed to be the place where we all come together, we learn from each other, we gain from the experience of being together. It's where society is shaped and common understandings that allow us to live together in relative peace come out of that. And when we take and we redefine the idea of religious neutrality as being discrimination and hostility against religion, and then we turn around and we privatize the public schools, which do so much of the work of bringing us together as a society, what we're left with is more deep, ugly, dangerous divisions. That's not something that we should be in a hurry to get back to. And yet I fear that it's the direction that we're going.
So you've talked about sort of what's going on with the threats to public education. And obviously, Holly and Richard and Randy, you pointed out the larger effects of the case too for religious freedom and even religion. But I want to go back to the threat to public schools for a minute. What is going on, right? What is at the heart of this movement that is attempting to divert funds from public education to private religious schools? Is this something new that we're seeing in our country? Has it been around for a while? And what's at the heart of it? What's motivating it?
That's a big question, Rachel, and I will, I'll answer it with a couple of assumptions, which is that we, there were a lot of things that were wrong with the original Constitution, even with the Bill of Rights, slavery, women not having the vote. I mean, so I don't want to make the framers be like the best thing in the universe. There were a lot of things that were wrong, but one of the things that were right was that people really understood, and that's why you had both no establishment and the free exercise clause. People understood that if religion was separate from government and that people could freely exercise their religion, but you really made it separate, that then you could actually both have religious freedom and you could also have a common understanding, as de Tocqueville said, about the United States. And, that has been part of, even with everything else that's going on in America, that's kind of been sacrosanct until now, even when you had the height of Catholic schools, parochial education, people saw that there was a separation, and and if someone chose to have a parochial school, they would pay for it, or, rich folks would fundraise for it, or things like that. What I think is going on now is it's actually not about religion at all. It's about power and control. It is about the sense that the country is becoming more multi-ethnic since, the Voting Rights Act actually was the first time we became a multiracial democracy. Over the course of the next 10, 20 years, in schools already, we are majority non-white in public schools. And I think that you're seeing, and think that we see the same thing in terms of Trump and what he has done, and how he not only led as a president, but what he's done since, that we have, I hope we don't get to a civil war, but a civil war over, are we a majority white country, or does majority white have the power, or are we a pluralistic society that lifts all up? And this push right now for privatization, it's kind of sort of not different than the push in the aftermath of Brown v. Board of all of a sudden the choice movement and the privatization and private schools movement. So I think what's really happening is these folks are using by any means necessary to try to maintain the power of basically white male power system in the United States. And I say that as someone most people don't think of as radical. I just think it's an observation of what's going on. And you see that in any number of ways, including on abortion, including on gay rights, including on the fight against CRT, which was like really manufactured. So I think that's the impetus here. And we are a multicultural, multi-ethnic society. That's part of what makes America America. And part of the potential here is that we could actually be the first multi-ethnic, multi-racial democracy in the world. But because of all that, we may also be one election away from autocracy. So the stakes here are not just about education, they're just huge. But I think that's the impulse behind what's going on.
I think that all of that is exactly right. And so what I will add, the piece I'll add is, the folks who make up the—
I'm sorry, Richard. See, I don't have to be a lawyer, so I can say whatever I want to say.
Absolutely. Anyway, the piece I'm going to add is that the people who make up the so-called school choice movement, it's a weird coalition. You have folks who send their kids to private schools and want to get it paid for, even though they're paying for it themselves to begin with. And you have folks who are looking for any opportunity that they can to get their kids out of the public schools because they feel that they're being failed by it. But the intellectual movement that's driving it is by folks who what they really want to do is to dismantle the public schools, and for a variety of reasons, right? It may be that they don't like government, because one of the phrases is to call them government schools rather than public schools, which I've always found rather interesting, because it's supposed to take out the idea that the public schools are supposed to be a public good that make us a community as a society. So they call them government schools, and we don't like the government, and so they're necessarily bad. Folks who don't want their money to be used, they say, for supporting somebody else's education, when traditionally we thought of it as the good that is supplied to everybody, that you can choose not to accept if you want to go and do something else. But it was the thing that really gave us all opportunities in society. And when Randy was talking about the power structures, I think part of that is you end up depriving people of the opportunities that the public schools are supposed to get if you dismantle. And the idea of privatizing and using a sort of a shopping metaphor to go and find schools really becomes a vehicle to do that. And so it's something much deeper than just sort of who's paying for my kids' education. It's really about what we're going to be as a society. And I think it's true that it's always at risk, and more today than it was 10 years ago, and more today than it was 20 years ago. And it's very worrisome. It scares me.
So we've been talking about these colossal risks to public schools and to sort of our society as it's intended to be, right? A pluralistic, diverse society. Let me come back to one particular of the case sort of and focus us in on sort of the threats around religious freedom and this new definition of sort of religious freedom really that's coming out of the courts, which is religious privilege. So this idea that, Richard, you named it, that like religious neutrality is somehow anti-religion. And so if you're treating religion, differently, or if you're excluding religion, you're discriminating against religion. If you're not funding religion as the government, you're discriminating against religion. So Holly, I wanted to actually start out with you and just go back to this idea about whether it's always bad for religion to be treated differently. than non-religion? I mean, because that feels like it's the assumption in this religious discrimination claim that somehow, you know, in the context of the vaccines cases, if stores which function very, you know, differently from a religious service are allowed to meet, or this is the sort of the closing cases around COVID and the public safety orders, somehow it's discriminating against religion if religious services are different and you treat them differently. So can you sort of center us on this idea that it's bad for, whether it's bad for religion to be singled out, or what's going on with that?
Let me start with speaking up. As Randy was trying to speak up for religious liberty, let me speak up for public schools. As a product of public schools, as someone who's related to public school teachers, as a mother of public school students, public schools have often taught religious freedom because they recognize individual opportunity for religious liberty and after school programs, praying before school, all kinds of different personal free exercise, at the same time maintaining religious neutrality by ensuring that teachers and coaches don't lead in religious exercises or discriminate based upon religion. So that's what we need to remember. And public school teachers and principals every day are trying to do that. So of course, in not being able to promote religion, but being able to promote good citizenship, that's treating religious differently. And that's not treating religion badly. In fact, many religious parents from different religions, you know, appreciate their public schools for that and what that does for their children and their neighbors. But more broadly, to your point, Rachel, of course, it's not bad to treat religion distinctly and differently in some circumstances. It is a distinctive endeavor that is treated distinctively in our constitutional tradition for no establishment and for free exercise reasons. And I can say that many of the advocates who are saying, treat us the same, give us the money, let these schools, let religious schools receive money from the state of Maine, would not argue that it is bad to treat them differently when it comes to regulations, hiring practices, admission practices. And we know this from this court because this court has had cases very recently where religious institutions argued to be treated differently because they were involved in the faith formation of students. These are private religious schools. And so the court can recognize that certain religious institutions, particularly with regard to what's known as ecclesiastical matters, matters of pure explicit religious doctrine and definition, that the courts can treat that differently, those institutions differently. And they've done that in some employment cases. I don't think a lot of religious people would say that's bad. I don't think a lot of religious people would say it's bad to treat religion differently when you allow certain religious clothing that would be different from a normal uniform standard, or treating religious students differently if they need an accommodation, a student or a worker, based on a schedule to acknowledge the need to have religious practices or participate in religious holidays. So this idea that anytime you treat religion differently, that it is necessarily bad, discriminatory in the invidious way, it's a new concept. And it's a damaging, horrible concept that does not fit with the best of our tradition that has protected religious freedom for all.
Rachel, can I just kind of piggyback on what Holly just said? I just want to, for everybody who's listening, what Holly just said, I'm going to say exclamation point, exclamation point, exclamation point. Because I think that there's and it's been interesting to be a fairly spiritual Jew married to a rabbi who's very involved in my own religion, which happens to be involved in the largest LGBTQ congregation in the world, and going through that struggle on religion, and now going through the struggle in terms of public education. I think what Holly just said is that we have to be really respectful of the freedom, the free exercise, which requires certain differences in terms of how one observes and respects people with deep spiritual religious values. And that, so there's not, but that then also means we have to make sure that the neutrality that the law used to suggest actually creates more freedom than what will happen with this new court. And so whether it's public schooling or any other piece of our life, what the court is actually doing is inhibiting and long-term restricting the free exercise of religion by yoking it in one way or another. And I think that Holly's observation here is just so brilliant, and that those of us who are arguing in this realm need to embrace that there are some differences with religion, but the issue about basically taking money from the public fisc and moving it completely so that we no longer have the investment we need runs afoul of both free exercise and the Establishment Clause.
Yeah, I'm going to throw up a few exclamation points on both of those, both what Holly and what Randy said as well. One of the things that I sometimes hear people say, even when they're recognizing this sort of funny thing that I think the Supreme Court has been doing more and more, and saying that if religion doesn't get the best special treatment of anything and anyone, then it is being discriminated against. I sometimes hear people say, look, you have to take the good with the bad, and religion gets certain privileges, and that means a lot of legal privileges, and that means that you also don't get to take money. You got to take the good with the bad. I actually think that that's wrong because of some of the things that Holly and Randy both said. It is both of those things are benefits, right? That religion gets left alone, so that religious groups and houses of worship can choose their doctrine and propound it, and people can practice their faith. And it gets left alone in not having the government give money to it, because that has a distorting effect. Look, I'm Jewish too, and yet one of my great heroes has always been, and I know the folks on our staff are going to roll their eyes because they hear me say this so often, has always been Roger Williams, the Baptist theologian who founded Rhode Island, who went through and very carefully explained that when government gives money to religion, it has a distorting, corrupting effect, and it does it in a couple of ways, right? One is that when the government is giving out funds, you might, you as a house of worship, a denomination, you might sort of subtly shift your doctrine to try to appeal to that person who's giving out the money, and that is a distortion and a problem for religious freedom. And the other thing is that the funding, the playing of favorites has a deleterious effect as well. And even when you're receiving the funds, even when you're the beneficiary of it, that is in fact harmful to religious freedom. So it's really sort of good things on both sides that come with the idea of separating religion and government. And I know I'm talking to, I'm preaching to the choir, or whatever you want to use here in our audience tonight. But that's really what's at risk here. And when the courts and when folks on the other side of these issues try to present the idea of neutrality as being discrimination against religion, hostility toward religion, they're missing something really essential in what religious freedom is and is supposed to be. And that too is deeply unsettling. Well,
and Richard, we were on the same brief that AU led and that civil rights and religious organizations joined. And I was very proud to be on it in the way that it showed that historically not funding religion goes right with for the protection of free exercise of religion, that these things are inextricably bound together. They were at the founding. And it was very surprising that this court that so often emphasizes what they call originalism, or at the very least, the historical meaning of the text, did not spend any time thinking about that or talking about that in a way that would at least give Maine a little bit of a benefit in deciding that it did not want to sponsor explicitly religious teachings as these schools offered.
That's a great point, Holly. Originalism only when it's useful. Richard does talk about Roger Williams a lot, who of course was the founder of the colony, right, of Rhode Island, a minister himself, who I think my favorite quote from Roger Williams about church-state separation is, "Forced worship stinks in God's nostrils." Which I also sort of love. And it's another commentary on how it harms religion to integrate sort of the state into religion. So it's quite a situation that we're in right now with the predominantly conservative justices who make up the Supreme Court. And there's so much more that I had to ask you all, but I think what I'd rather do, rather than continue to ask you, is to actually make sure that we're bringing in the questions of our listeners, and you can respond to those instead of to mine. So Brian, I'm going to pass the baton back to you to ask some questions from the crowd.
Great, thank you very much. So the first question, I'm going to pose it. There might not be enough information, in which case I'll just ask for the attendee to resubmit it with more. But the question was about, did you feel that John Roberts misled counsel for the state? And did the counsel kind of fall for that? If that doesn't ring a bell, then we'll just ask Jordan to resubmit the question with more context.
Does anyone want to take that one, or is it? I think it's a little. One might still be a little confusing. Why don't we have Jordan add a little bit and move on to another one? Brian.
Perfect. Yeah. So the next question was one of the attendees was asking, was there anything positive that you heard in the arguments? Anything that would give any hope that the court would actually protect the freedom of taxpayers in this case? So looking for any positive news that you heard.
I am related, friend. I am always looking for the positive. A quick note about Justice Roberts. I think maybe one thing about that is that, he's the guy who came up with the status use distinction, which we had to work really hard to understand, but then we understood it and we stuck to it. And then, now it's not so important here. So that was something where maybe Roberts it seems like he's being a little tricky there. So I did want to know that, but the only positive one positive is that, the justices really did nail down the advocate to be clear that, he could not argue that state funding was required for these religious schools if it was given directly to the schools, that it was only by adopting, basically redefining the benefit as some kind of broad choice benefit, even though it doesn't look to me like that's what Maine created, but only by a kind of adopting that view would his argument succeed, that, that Maine has created some kind of choice program, and you can't, based on Espinoza, you can't discriminate between private school funding and private religious school funding, which of course, for the reasons we've talked about, is problematic. But at least he was clear, and the justices pressed him, that public schools, public entities can continue to preserve their public funding if they do so very, very carefully. And they make their interests really, really clear, that there's no religious animus. There's no, there's nothing that would kind of fall into this idea that religion is being punished or treated differently for some discriminatory purpose.
Can I just want to piggyback on what Holly said. The Maine case, and I didn't listen to the arguments. I, read a bit of a transcript about it, but the Maine case makes it clear that the vouchers are for public education in other public jurisdictions, because there's not enough kids to have, a public high school, or, in every single county or every single village. And so it's going to be, the only silver lining I saw for the case was that really did bug the justices, that all of a sudden, if you give money for a different kind of construction of public education and you call it a voucher, that's still for a public purpose. And I think from what I looked at in terms of the transcripts and hearing a bit of the debate afterwards, the justices seem to draw that line. So I would say that's the only silver lining I saw.
And the very thin read that I can put onto this is, I don't think that there were any takers for the idea that because states and localities fund public schools, that they automatically have to start funding private religious schools in the process. There's something about the mechanism of, funding some private schools that the court is that was what was bothering the justices. And but the idea that you can just have a public school system and be done with it should be fine. And so that sounds like a simple thing, but I do think it matters for this reason. One of the things that I think bothers a lot of people about what's going on here, and Rachel started us off with this when she talked about what the case was about, was the fact that the two schools that the plaintiffs in the case, the families that were challenging it, were trying to send their kids to, discriminate. They won't hire LGBT faculty. They won't let kids who are LGBT or who have same-sex parents attend, and on, right? As well as saying you have to be of our faith and all the other things. And one of the things that because the public schools are supposed to be open and welcoming and inclusive for everyone, and a lot of people are bothered by the idea, and this gets to the question about taxpayers, that my money is going to fund a place that wouldn't accept me, wouldn't accept my kid, that is using my money to exclude people who I don't think should be excluded. And the answer we may be left with is the only thing that you can have is public schools, and I think that's a good thing. The only thing that can be funded, but it does, given that there's been such a trend toward making government money available for private education, it means that fight is even more important, to make sure that the money for education is going for the public money for education is going for purely public education, so that we're not funding discrimination. So there's a little bit of a positive thing, but also I guess a challenge for our advocacy for the future.
Well, it's not at all clear.
Richard.
Yeah.
Oh, go ahead, Ollie.
That's okay. We can get to another question, but I would hold on to that silver lining that at one assumption of public schools, even if the court doesn't see that, one assumption of public schools is that they are religiously neutral. Another one is that they are open to the public, that anyone participating in a public school program, whatever, even a choice program, would, be open to students without regard to protected categories.
So we had a couple of folks that asked, is there any chance that the court would decide this based on standing, or that the standing argument would succeed? If that's a yes or no answer, feel free. But if there's some explanation, I'll let each of you go ahead and answer that. And maybe if one of you could just explain a little bit what that standing argument is for folks who might not be familiar.
I don't think they'll decide it on that. Now, Richard, you can tell them what it is.
Sure. I agree with Holly. So for the non-lawyers, standing is the requirement that you have to show that you are actually injured by the thing that the government is, if you're suing the government, that you're actually injured by the thing that the government is doing, and that if you win the case, that injury gets, that you get some kind of a vindication, right? So you can win something so you can end the injury. what's going on here? The families are saying that because we want to send our kids to these particular religious schools, and the state would pay to send them to secular private schools because we live in one of those districts that doesn't have public schools, because the state would pay to send them to secular schools but not to religious schools, that we're being discriminated against. And so their claim of injury is, we deserve equal treatment with, this is the way they put it, the neighbor who wants to send their kids to the private non-religious school. The problem gets back to a little bit of what I was saying before, and what Rachel was saying at the beginning, is that the two schools that the parents want to send their kids to don't want to take the money. They've said they aren't interested in taking the money from the state, because when you take, this gets back to the Roger Williams puzzle, when you take government money, there are requirements that are attached to it. One of the things that the state of Maine says is, there are certain ways that if you're taking the government money, the state money, you can't discriminate. Now, they actually allow them to discriminate in who they hire and fire, but that they couldn't do all the exclusion of the kids for whatever reasons they might want to. Schools don't like that, because they really want to make sure that they keep out the gay kids and they keep out the kids of other faiths. And so, because they don't want the money, the parents can't actually get what they want, right? They couldn't get the state to pay, because if the state pays, the schools will say, nope, your kids still can't go here. That should mean the parents can't win anything that they can use, and therefore the courts shouldn't be deciding the case. Yet I agree with Holly that I don't think that will deter the court. I don't think that the court will decide things on that basis. I think it should, but I don't think it will.
So the last question that we're going to ask is kind of another combination of what folks have asked, but kind of, what happens next? What if we do lose Carson? What are some of the potential immediate effects? What are some of the ways that we might be able to, ameliorate that, either through legislation or regulation, how folks can remain involved, especially with each of your organizations around this case, and also the issues that it raises. As we've heard, this case will affect, many different issues. So if we go around and give each of you a chance to answer that, that would be great.
Randy, do you want to go first?
Sure. So regardless of what happens in Carson, our work is the same. Public education is a public good. And in the 50 states and the territories, it's one of the few public goods that basically say to kids and their parents that we're going to do everything we can to actually make sure that you thrive, to help you get an education, help you build relationships, develop resilience, critically think. And so the resources to get that done are really important. And the question I would ask, as put on my non-lawyer hat, is regardless of what happens in any of these cases, what is the investment that we need to make sure that there is a viable public school choice, so that parents have the choice to send their kids to public schools that they want for their kids, that educators want to work in, and that kids thrive. And that will mean, if you have these kind of cases, that taxes will go up to get the investment that's needed for this kind of work. So less the religious schools discriminate, or there's an issue, or blah, 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 much more of what is the ramifications to everybody who stays in public schools for us to be able to do what we need to do to help every single one of those kids thrive.
I'll just come in here. I'll participate in this one really quickly. And I know we're almost at the end of our time, and just say that Americans United for Separation of Church and State is going to be 75 years old next year. And when we first came into being, by the way, because of the work of a group of religious folks in my hometown of Chicago, mostly, the New York Times published an article about our debut and our manifesto. And in our manifesto was supporting public schools, because advocates for church-state separation understand that public schools are inclusive, and public schools forge a sort of a unity in our society that allows for acceptance of all of us. So I would say, Brian, in response to that question, to support public schools and fight this private school voucher movement, you know, and join those coalitions in the states, because these battles are very real. And after the Espinoza decision, and I imagine this one, we're in trouble when those programs expand and when they pop up. So fight those, and also, to state the obvious, make your church-state separation advocacy sort of more prominent, bring more people along on the threat to it, because if anything is showcasing that threat, it's cases like Carson V Macon. And so take it to your religious community, take it to your secular community, your LGBTQ group, your whatever groups, your yoga class, wherever you go, you know, sort of help bring people along, because it is central to inclusion, to public schools, and to democracy, you know, and it's really at risk. Richard, Holly, how about you two?
I agree that being involved in public schools is something positive you can do, and to you know, answer the charge, the unfounded charge that the schools are hostile to religion by, you know, speaking up. The religious people are in the public schools. They don't expect public teachers to be responsible for their children's religious education. They're an essential religious formation, but you know, to fight this idea that unfortunately, you know, some members of the Supreme Court are taking, you know, have taken on that that neutrality toward religion is hostility, and instead, it's just really difficult work. You know, as Americans, we all value our independence and our individual liberty, and it's hard work to come together as institutions and respect each other and work together, and that's exactly what's called for.
Yeah, that's right. Look, speaking up together really matters, and there is a really concerted effort from folks on the other side of these issues to present things as you know, religion is all on that side, and it's hostile to religion on the side of protecting the public schools and protecting public education. And so one thing is to show that we, as people from all different faiths and non-believers, all come together with the same views, the same shared thing, even though we disagree on lots and lots of things, but that we together share certain beliefs about what kind of a society we should have and what religious freedom actually is. And so all the voices, whether you're an educator or not, or a parent or not, or religious or not, to join together and say, we see this issue the same way, and it's important, and don't make the mistake of thinking that you can count us out or that we don't exist. That matters a huge amount.
All right, great. Well, you know, I want to say thank you so much to all of our panelists, to Richard Katzke, to Holly Holman and Randy Weingarten, and also to our moderator, Rachel Lazar. I also want to thank all of our attendees for joining us tonight, and look out for the link to the recording of tonight's town hall in your email tomorrow. While we await the decision in Carson, the work continues every day to ensure strong public schools for all, and a robust separation of church and state that serves as a shield that protects real religious freedom for all. You can find out more about each of our organizations and connect to our social media on our websites. American Youth United is at au.org. The Baptist Joint Committee is at bjconline.org. and the American Federation of Teachers is at aft.org. And finally, I want to again invite you to join us virtually in March of next year for the Summit for Religious Freedom, where we'll continue these types of conversations and more. You can pre-register and get more information at thesrf.org. That's the SURF, srf.org. Thank you all again for being with us in this fight, and good night.